your next part of your presentations and the next part of the unit, we're going to get into the First Amendment. We're going to break it down into two presentations. The first one is going to be dealing with the freedom of speech, the freedom of press, the freedom of petition and assembly. And then your second presentation will be covering the freedom of religion. What you want to make sure you're doing as you're watching and listening to the presentation is answering the questions using both the audio and the visual to help you get the answers to the questions then, and make sure you just get the material and understand it pretty good. Alright, the first part that we're going to get into then is talking about this chart, and we're going to talk more about this in class even, dealing with the First Amendment. And what's interesting about this chart is that there was a survey that was conducted by an organization which wanted to find out what of the First Amendment freedoms would be the most threatened if the government or court cases or the Supreme Court would put limitations on. And it was interesting that 23% found freedom of speech and 23% found the freedom of religion as the two amendments that would be the two freedoms, that would be the most threatened. And when you look at this survey and break it down even more, what you found is that the conservatives, the Republican side ideology, thought that it would be the freedom of religion. So of the 23%, a vast majority of those are conservative Republicans who view that that freedom is being taken away from us more and more, whereas the liberal Democrat side viewed it as the freedom of speech is being limited and being taken away from us more and more. So even though it's 23% of the survey, when you break that 23% down, it's a bigger majority going for one ideology and the other, and that is also very interesting when you hear and listen to both sides of the ideology battle going on about how our freedoms are being taken away from us. It depends upon your viewpoint as to which of those freedoms it is. Then you have the freedom of assembly and petition, which are also not as high, but kind of high there on threats being taken away there as well. And again, it depends upon your viewpoint. When it came to freedom of assembly, which is the right to be able to get together and to protest. Again, it's very much a liberal Democrat side that is viewing that as being taken away. And then the freedom of petition is, again, much more of a conservative viewpoint that is viewpoint being taken away. And then the last part of the survey that was interesting is the 10%, which is a very small percent of both Republicans and Democrats view that the freedom of press is a threatened freedom in this country. And both of them basically do not view the freedom of press as being limited. They view it as being too much powerful and being able to control too much of what goes on in our society with their viewpoints, opinions, rather than the actual facts of the news then. So that's an interesting survey that in pertaining to the five freedoms of the First Amendment. Okay, the next part of the presentation then is going to get into the limits to the freedom of speech, and it's going to get into very different types of court cases dealing with these limits on freedom of speech, because you do not have just whatever you want to say and however you want to do it. And same with the freedom of press and the freedom of assembly and petition. There are limits to it. So the presentation is going to get into that. The person speaking is a former student of mine, Amanda Miller, who's going to present these limits to the freedom of speech, petition, press, and assembly, and she's going to go through those then. And again, you want to make sure you're listening to the presentations very carefully and getting down all the information from it then.
Having the freedom of speech doesn't necessarily mean someone can get away with everything they say without getting into trouble. There are some limits, and these include clear and present danger, which is the freedom of speech does not count with statements that provoke or entice illegal action. For example, if someone were to say, "I am going to kill you," that would relate to clear and present danger. Another limit is fighting words. It has something been said face to face that entices violence. For example, name calling. And finally, there's libel and slander. One does not have the right to say lies that damage the reputation of another person or group. For example, if Burger King were to say, "Eat Burger King because Wendy's poisons their meat." The rules for this are that if it was put in a way that makes context seem misleading or a false statement is made, it is libel and slander. Remember, slander is spoken or through speech, and libel is written. Obscenity is the judgment of what is considered obscene or offensive, and says that things considered obscene could not be protected by the First Amendment. In June of 1973, Miller v. California came up with a three-part Miller test to declare whether or not something was obscene. The three-part Miller test mainly consists of three major questions. Would the average person applying the contemporary community standards and viewing the work as a whole find the work appeals to the prurient taste? Does the work depict or describe sexual conduct in a patently offensive way? Does the work taken as a whole lack serious literacy, artistic, political, or scientific value? The current Supreme Court definition of obscenity is: a thing must be prurient in nature, a thing must be completely devoid of scientific, political, educational, or social value, and a thing must violate the local community standards. The John Stagliano court case is an example. Stagliano was facing 32 years in prison and a $7 million fine for the use of obscenity in pornography. Stagliano is a big-name producer, and his case was one of the first of its kind in Washington, D.C. for 2 decades. The porn charges on Stagliano and his Evil Angel company were eventually dropped. Seditious speech is speech used to overthrow the government. This includes speech attacking particular leaders in government and institutions of government. An example is the Alien and Sedition Acts passed by Federalists in 1798 in Congress. President John Adams signed the act into a law. Through the Sedition Act, public opposition of the government was considered illegal. You could not write, paint, utter, or push any false, scandalous, and/or malicious writing that opposed the government. Although the Sedition Act was constitutional, judicial review was not yet in place. The Alien and Sedition made it easy to deport the foreigners and made it where immigrants had to live in the U.S. for 14 years before voting. Historians believe this was intended to decrease voters who disagreed with Federalists. Next, the Smith Act. During the 1940s, this was technically called the Alien Registration Act. This act made it an offense to belong to or create a group that encouraged a violent overthrow of the government. This act was used to lead to the prosecution of some of the Communist and Socialist Party members. Finally, the Military Commission Act in 2006, this prohibits those who have been classified as enemy combatants, which are terrorists, from using their habeas corpus rights while being held for trial hearings. The Supreme Court ruling cases include clear and present danger ruling, which came from Schneck v. United States in 1919. A man was charged with distributing provocative flyers to the draftees of World War I, and the court says that words can create a clear and present danger. This is still relevant today. Next is the bad tendency rule, which came from Patterson v. Colorado in 1907. A newspaper publisher accused a Colorado judge of acting on behalf of local utility companies. This rule restricts freedom of speech if what is being said will incite or encourage illegal activity. This isn't really in use today because it was replaced with clear and present danger. Next is the grave and probable danger, which came from Dennis v. U.S. in 1951. It's a modification to the clear and present danger ruling. It makes it a crime to teach or advocate the violent overthrow of government, to set up an organization to teach or advocate the overthrow of government. This is replaced by the incitement test, and it is still used some today. The incitement test is derived from Brandenburg versus Ohio in 1969. States that the government cannot punish inflammatory speech unless that speech is directed to or inciting or is likely to incite imminent lawless action, and it is still used today. Prior restraint is the government cannot stop you from publishing or expressing your ideas, but you can get in trouble for saying false information after it has been published. For example, the government cannot just say, "No, I do not think you can write that. It will make us look absolutely terrible." In Neer versus Minnesota in 1931, prior restraint was justified. A small Minneapolis newspaper, the Saturday Press, had crudely ridiculed political officials and local police. Law decided that further publication was punishable. Some court cases, for example, is the New York Times versus United States in 1971. It made it possible for New York Times and Washington Post to publish the Pentagon Papers without the risk of censorship or government punishment. The government basically said that making documents public would put the nation's security at risk, while the New York Times and Pentagon Post said that it was their right or their First Amendment and the freedom of speech. Some future influences on this case is when this case ruled in favor of protecting First Amendment rights, it set a standard that would lean towards protection of First Amendment in similar cases. Another court case is the Hazelwood School District versus Kohlmeyer in 1988. The Spectrum School newspaper was about to print an issue of 2 stories the principal was skeptical about, one on a teen pregnancy and one on divorce. After looking over the proofs, the principal printed a 4-page issue instead of 6 pages and opted out the 2 pages with questionable stories. Kohlmeyer, the editor of the newspaper, argued violation of his First Amendment rights, his freedom of speech. The Board of Education said that Principal Reynolds was concerned that the pregnant students might be identifiable, even though their names were changed. He also thought that the divorced family should have consent to publish the story. The decision on which way this went is the principal is entitled to censor the articles. Educators are not infringing rights when exercising control over student speech in school-sponsored activities. For future impact, educators, school officials can censor non-form school papers if they have educational reason for doing so. Finally, Tinker versus Des Moines Independent Community School District in 1969. This case involved an Iowa school, John Tinker, Mary Beth Tinker, and Christopher Eggehart, who were wanting to wear black armbands to school to support Senator Kennedy's Christmas truce and protest the Vietnam War. Principals met and created a policy against the armbands. Principals saw this as a disruption and believed that they had the ability to stop the expression of the armbands. Tinkers and Eggehart believed it was their First Amendment right to express themselves. A 7-1 decision in court said that the kids have right to freedom of speech unless principals could justify that if action was causing problems other than an uncomfortable, unpopular viewpoint. Tinker's case is frequently used as a standard for cases like this one, but the court has created limitations on students' freedom of speech. DeJong versus Oregon in 1937. This is a case in which the Supreme Court held that the 14th Amendment's Due Process Clause applies to freedom of assembly. For example, the KKK wanted to do a march on a small Jewish town that would possibly cause an uproar. There is a meeting held by the Communist Party in jail conditions and organizing a strike where the police raided the meeting. They had the right to assemble even though there may be uproars that occur. They cannot stop them before the federal government, but they can prosecute them if there is any trouble. DeJong won in the time, place, manner is when the government can decide when, where, and how.
Okay, and